Thank you. And thank you for joining us for Litigation Basics, episode number 1, TROs and preliminary injunctions. My name is Stephen Reingold, and I am your moderator. This webinar is part of the Financial Poise webinar series, Litigation Basics. Slide 7 summarizes this episode, and slide 8 provides a summary of the series. Speaking of the slides, you should understand that we will not step through the slide deck in order, nor will you have to listen to us read any slides. This webinar, like all Financial Poise webinars, is a conversation. Keep the slide deck handy, however, because I will try to indicate what slides our conversation is touching on as we proceed, so you can take notes. Our panelists today are Jeff Leon, a partner at Karen LLC, Timothy Pastor, a partner at Montgomery McCracken, Walker and Rhodes, Jonathan Horn, a partner at Harris Beach, North Carolina, and again, my name is Stephen Reingold, and I'm a partner at Sol Ewing. And we appreciate that you're not spending your time and money to attend this webinar to hear infomercials about us. You can read more about us on slides 33 through 36. This webinar is a production of Financial Poise. To sign up for our great free weekly newsletter, go to www.financialpoise.com or send an email to info@financialpoise.com with the word subscribe in the subject line. This webinar is being sponsored by the National Law Review, Type to Learn, and Max Asset. We thank you for your sponsorship. If you're attending the live premiere of this webinar, you can submit questions using your web portal. If you're watching this webinar on demand or have any questions after the webinar, you can send an email to info@financialpoise.com. Just include your question and the name of the episode, and we will do our best to get you an answer. Okay, with those preliminary remarks, let's get started. And so, Jeff, we're going to start with you. We're going to begin at the beginning. Would you tell us, please, the difference between a temporary restraining order and a preliminary injunction?
Yeah, there are some universally general differences, but of course, what it means can differ among different state rules and, of course, between state and federal court. But essentially, the purpose of a TRO is to go in and freeze the status quo immediately. As the slide says, it can be time limited for 10 to 14 days under the federal rules. 10 days, it's renewable a couple of times. It can be ex parte, meaning the other side may not yet even be served or show up, although judges don't always love that, but sometimes the exigencies of the circumstances actually do require that. And the purpose then of the TRO is usually to freeze things so that there's time to have a preliminary injunction hearing, which is oftentimes a mini trial before the judge. And then a preliminary injunction can be open-ended. It can last all the way through the time that a trial occurs. You have to give notice for a preliminary injunction, and that's more or less the key differences. I mean, there are bonding requirements that may be different. If you win a TRO or a preliminary injunction, you may, depending on what jurisdiction you're in, you may have to post a bond to cover the other side for any potential losses that they may incur as a consequence if it turns out that on the merits after a trial that the TRO or preliminary injunction was wrongly issued.
Great, thank you for that. So, Tim, let's move to you. Let's start to get into some of the strategy. When should a party consider moving for a TRO or a preliminary injunction?
Well, thank you, Stephen, and it's good to be with Jeff and Jonathan presenting on this topic. So I want to build on Jeff's answer because one of the items that he mentioned is preserving the status quo. So in a circumstance where you're concerned that your adversary may do something that prejudices your rights or inhibits you in some way, and you want to make sure that they don't do that or don't continue to do that, you certainly should discuss with your counsel the prospect of a TRO and preliminary injunction to preserve the status quo where you want to stop something. So very common, almost silly example for this purpose is the boat is leaving the dock. And you don't want the boat to leave the dock. You want to get an order enjoining the boat from leaving the dock. In fact, I once appeared for a TRO in federal court in New Jersey, and it was a Friday afternoon, and we were very eager, and I think we had the merits on our side. Ultimately, we prevailed. But on that evening, the clerk asked, "Is the boat leaving the dock?" And we really couldn't say the boat was leaving the dock. And by the way, our case had nothing to do with boats or docks. But nevertheless, that's the question that was posed to us metaphorically to suggest that they weren't going to consider a TRO in that moment. Ultimately, we did get an injunction in that case, but there are times where you want something to be stopped and stopped immediately, and that's where you would consult with your counsel and consider bringing a motion for a TRO or a preliminary injunction.
Okay. Jonathan, let's pivot to you now. There's a handful of situations we've all dealt with as practitioners in which we've sought injunctive relief. What are some of the common types of cases in which injunctive relief is sought?
Sure. And thanks, Stephen. Good to be here as well. Well, the short answer is that a TRO or preliminary injunction may be appropriate in any case where there's an ongoing harm or a risk that the plaintiff will suffer some irreparable injury that cannot be undone if there's not an order entered promptly. So the relief itself is not per se limited to any specific type of case. But with that said, there are a number of areas where seeking TROs and preliminary injunctions is a pretty common tactic in the litigation. And I'll just go through a few here, which are also listed in the slide. One common area are cases involving trade secrets or the potential release of confidential information. In those cases, once the trade secret or confidential information is out in the public domain, the damage is done, and it's very hard to undo that harm once a secret's been made public. So that type of case is one where plaintiff will often seek an emergency TRO at the beginning of the case to prevent the disclosure. For similar reasons, it's common in cases involving employee non-compete agreements or non-solicitation agreements. If you have an employee that left with your entire customer list to go work for one of your competitors, if you get a judgment against them a year and a half from now, it's going to be a Pyrrhic victory when they've taken all your clients and all your business. So in those types of cases, you often seek an order at the outset, basically ordering that the employee can't use the confidential client information. Similarly, trademark or copyright infringement cases are another common area. If a plaintiff can show likelihood of success on an infringement claim, a court will generally issue an injunction because the damage to the plaintiff will accumulate each day that the infringing conduct continues. It may cause lasting damage to the brand if nothing is done until a judgment is obtained. It's also common to seek a TRO or an injunction to freeze or attach a bank account or some other asset that's easy to move or easy to dissipate. And this is one area, I think we'll get to ex parte relief a little bit later in the presentation, but this is one area where ex parte relief may be appropriate because if you give a defendant notice that you're seeking to attach a bank account, well, they can just move the funds to a different account, to a different financial institution. Another type of case is involves sale of property. Again, if there's a pending transaction that's about to close and you're seeking to stop that, you're going to want to seek a TRO or an injunction to stop the sale, preserve the status quo until the the litigation can be adjudicated. And then finally, another area are cases involving constitutional rights. And there's one prominent example that has been in the news here in the last week or so, which involves the litigation that was brought by several states over the president's recent executive order on birthright citizenship. You may have read that the judge, within a day or two of the lawsuit being filed, issued an order blocking that order from taking effect. Well, the order that's been issued so far is a TRO, a temporary restraining order, and the court has scheduled a hearing for a preliminary injunction, which is the order that would continue during the course of the litigation, I think for February 6th, to determine whether a preliminary injunction should issue. So Those 6 are some of the most common types of cases. But again, if you have a case where there's continuing harm and you need to, or you need to preserve the status quo while litigation is pending, you should determine whether seeking a TRO makes sense, even if it's not one of these types of cases.
So, Jeff, let's go back to you for a moment. We're talking about running to court for interim injunctive relief. What if you're litigating an issue governed by an agreement that has an arbitration clause? Can the party bound to arbitrate disputes still seek a TRO or a preliminary injunction? And if so, how does that work?
I mean, that's a complicated question without a entirely 100% clear answer. Usually, your purpose in obtaining injunctive relief from a court is even more limited. If you're bound by an arbitration agreement, you get that, and it will be predicated solely on giving the arbitrator time to hold a hearing to decide whether or not injunctive relief should be granted. And then the crazy thing is you may then have to go back into court to take that arbitrator's ruling and get it entered by the actual court in order to make it enforceable, because complying with arbitrators' rulings can sometimes seem optional to parties. They lack the teeth that court orders have. So it is, a bit of a, an obstacle course, when you're dealing with arbitration clauses. In the one thing we should talk about just for a quick second, TROs versus preliminary injunctions. TROs are most often filed right at the outset of a case, but not always. And so that's important to keep in mind. Preliminary injunctions, by the way, you don't have to file a TRO in order to seek a preliminary injunction. That hasn't been said yet. They're certainly related. If you can tolerate the pain that is the predicate for your preliminary injunction motion until a limited quick discovery can occur on a preliminary injunction and a hearing held, then you don't have to seek a TRO. And there are tactical considerations as to whether to seek a TRO or not, because we haven't gotten into the requirements yet, but the requirements are kind of the same for both, but they are much more strictly construed in the context of a TRO, because the judge is doing more of a quick look and not the deeper detailed analysis of taking evidence and hearing. TROs are almost always on the papers, and you may get 20 minutes sometimes with a court in entering it. Sometimes they'll even just take it on the paper. They don't have a lot of time, and your urgency ensures they don't have a lot of time. They more or less have to rule that day or the next day. So, these are all important considerations. And if you have an arbitration clause at play, you have to consider how you're going to approach things. You can pretend you don't have an arbitration clause, which a lot of people do, and file in state or federal court, and then make the other side try to compel you in, or you can concurrently file your arbitration, file your motion for a TRO, and relate the two together.
And even though our topic today is really geared for new litigators, one of the things that I often see my transactional colleagues do or come to me as a litigator to review their documents on their dispute resolution provisions is to bake in language that if there is arbitration, that the parties agree the arbitrator has the authority, if not granted by the rules of the either AAA or JAMS or CPR, whatever entity they're using, that the arbitrator, he or she can bind the parties by an order equivalent to a TRO or a preliminary injunction. We've seen more of that lately too, and which makes it, with everything you just described, it's another wrinkle into the the decision points you have to cross. All right, Tim, let's go back to you. So Jeff touched on this. Let's do a deeper dive. In order to get a temporary restraining order, what is the procedure and what does the party seeking that TRO need to demonstrate in order to prevail?
So I think an outgrowth of what Jeff commented on is the first step you need to do is assess your rights under any applicable contract. And if there's no governing contract, you still need to undertake where you can pursue the TRO in the first instance. So the example you mentioned a moment ago, I have very recent experience with, where we had an agreement to arbitrate, but we sought contemporaneously relief from a court for a TRO and injunction. And so we did this contemporaneously. We referenced the need to arbitrate the underlying dispute, but we sought immediate interim relief in aid of arbitration from the court. And to do that, we had to first assess the contractual rights governing the parties' relationship. So I do think that's a first initial step, and that will not only determine whether you're in arbitration, whether you're in a court, but also geographically, what forum you're in, what state, and whether you're in state or federal court. So those are some of the initial considerations. Then you have to consider whether you meet the standards, and the standards are going to vary from state to state as to whether you can meet the elements of getting a TRO. We've got 50 states, they each have their own body of law, and they might differ. Nevertheless, generally, you have to demonstrate a likelihood of success on the merits. You have to demonstrate that you will be irreparably harmed in the absence of a TRO. For those unfamiliar with the term irreparable harm, although it was mentioned earlier, that just means money damages are insufficient. You have to demonstrate that money damages are insufficient and are hard to calculate. Therefore, the irreparable harm will result in the absence of an injunction. And in many states, you also have to demonstrate that the issuance of a restraint is consistent with the balance of the equities, which is a strange phrase that essentially means, I think it's fair that under the circumstances that some restraint issues. So those are the core elements. They may vary state to state. You then have to consider what evidence you need to support the contention that you meet these elements. That evidence could be documentary evidence already gathered in your possession. It could mean the pleadings from the case, although typically those are not evidence, but they could have evidentiary value if they've been affirmed under oath by someone with personal knowledge. You could have, in addition to the pleadings being affirmed, you could have separate affidavits from your client or from others that validate the claims that you're making, and any other evidence that you think supports your contention. In addition to gathering that evidence, you will draft a proposed order that will specifically seek the type of relief that you're seeking, specifically a restraining order, but you have to determine what should be restrained. You do not want to make the judge guess what should be restrained. You should map it out. And it's quite common for judges to receive proposed orders in these settings where you're filing an emergency motion for a TRO and to cross out certain things or add certain things to your order because it is something being decided typically on an emergent basis, and they don't take the time to have you resubmit a new proposed order in most cases. They'll just mark it up. And that's fine, provided that it gets you the relief that you're seeking. In some cases, you have to give notice. Here in New York State, for example, there is a rule that you've got to give 24 hours notice to your adversary when you're seeking a TRO by what we call an application for order to show cause. However, if you can show that damage will result to you by the giving of such notice, and you can present good cause why damage will result to you, then you can skip the notice process. But again, you have to demonstrate why notice could prejudice your application in some way, and you will be challenged by the judge on that issue. So there are times you give notice and times you don't give notice. Also, there was an allusion earlier to the need in some circumstances for a bond. It may be that the court will grant you your restraint, but subject to you getting a bond in a certain amount. So you need to prepare your client for the prospect of being ordered to get a bond in a certain amount. I had a case years ago where we got interim restraint, but my client couldn't get the bond. And that obviously interfered with our ability to maintain that restraint. We did work out an accommodation with our adversary, which was favorable for the client, but ultimately they did not get the TRO because of the failure to post a bond. So there are a series of elements. I've roughly listed them, but every case is different. And so it's best if you assess the facts of your case and take good counsel to determine what the exact procedures are that you want to follow to get the best result possible.
Thank you, Tim. So Jonathan, let's move back to you. Let's pick up on something that Tim mentioned. So, sometimes under certain state rules of civil procedure, you must give, subject to being excused, notice to the other side before getting a TRO. New York has its process. Massachusetts, it's very different. In state court in Massachusetts, some of the counties, it's like fish in a barrel, getting an ex parte TRO. So is there any benefit to providing notice to the other side, or if you have the ability to go ex parte, should you just do so?
Yeah, it's a great question. And in the audience, you all may be thinking, if the rules give me the option, surely it's better to proceed ex parte and not to have to face any opposition in court. But really, you should think critically about whether to try to proceed ex parte. Courts generally do not like granting ex parte relief unless there is a compelling reason for it. Our entire civil litigation system is premised on the adversary process, where both sides get notice and due process and have a chance to present their best case or defense while being challenged by the other side. So you want to make sure that you have compelling reasons to proceed ex parte. So, and even when a matter is time sensitive, you may be better off if you provide some notice, even if it is just the same day or even just prior to the hearing. As Tim said, 24 hours notice in New York is sufficient under most circumstances. But with that said, there are situations where ex parte relief is not only appropriate, but really is necessary in certain circumstances. And it could involve, just time sensitivity. Literally, there's a transaction that's scheduled to close later that afternoon, and you need to get an order before that occurs. If there's a real risk that the conduct that you're seeking to stop will be more likely to occur if you give notice. For instance, the example I mentioned earlier with attaching a bank account or freezing an asset. If the other side has noticed that you're going to do that and the assets are easily transferable, there's a great harm that giving notice will actually cause those assets to be transferred. So you want to proceed ex parte. Now, if you do decide to proceed ex parte, you should be ready not only to, make the case to the judge as to why the TRO should be granted, but the more important argument may be, justifying to the court why it should be done on an ex parte basis. Court could still agree with you 100% on the elements of entering a TRO, but feel as though it's not a true emergency and not a true ex parte situation, and deny the motion or continue it to give you time to give notice to the other side. So you really need to be sure that you have a legitimate basis to proceed ex parte if you choose to do so.
Right, and just, one of the things we find very useful in these presentations for our audience is war stories. We've all talked about them. I'll give one just very quick one. Even when you decide to go ex parte, the court may decide, no, I really want to do this on notice, even if it's a shortened notice. And we had a case, we went into state court in Texas to try to stop a foreclosure sale of some commercial property. And when in ex parte, the court said, I want to hear from the other side. Let's come back tomorrow. Back the next day, the court denied the request for a TRO, allowed the foreclosure sale to proceed. We went to the intermediate appellate court in Texas, which reversed. But by the time the order hit the docket in the appellate court, the foreclosure sale had already happened. The hammer had already fallen. So, everybody's talked about already game planning out what you need to do. But, timing is critical. Venue is critical. So map out everything you need to do and execute as quickly as possible, because you might not get a judge who agrees with you that it's either a true emergency or that ex parte relief is appropriate. So be prepared.
And
Jeff.
Steve, if I
Yes.
can, before you, I
Please.
just want to add 2 quick points about the ex parte strategizing.
Yep, absolutely.
One is you run the risk, if you go in ex parte, that the judge is going to take a more jaundiced eye to what you're trying to do, right? Because you didn't bring the other side in. And the judge knows that he or she is not going to be getting, the full story, both sides of the coin. The other risk you take is some judges, if you go in ex parte, feel obligated to stand in the shoes of the ex parte party who's not there, and start to ask you much more difficult questions than perhaps the other side would be doing. You can always expect judges on a TRO to be much more active than they are in just deciding a regular old motion, because they got to craft this thing if they're going to enter it. And you just may swing them a little bit towards the ex parte party's side because the judge, is thinking they need some advocacy in order for that judge to test what it is that they want to do. There's weird elements of psychology that go into this. So, to reiterate the point that Jonathan made, use great care if you're going in ex parte. There better be a darn good specific reason to do that.
Excellent points. And we've all bumped into those judges who have done exactly what you just described. So let's stay with you, Jeff. So we touched earlier about the bond requirement, and let's just kind of finish that conversation. Is it always required to post a bond to get a TRO?
It's not always required. It really depends on the nature of what you're asking for. If you're trying to stop somebody from selling a property in the example that you used, there could be economic damage that results to the party that is enjoined by a TRO or a preliminary injunction. And the court is going to want an estimate of what that would be. And then that would be factored into the bond amount. And so and of course, what would happen just procedurally, playing it out down the line to understand why there's a bond requirement, is say that ultimately the injunction is lifted, or it proceeds to trial and the party enjoined from selling the property wins the trial. Now the injunction was improperly issued. The party who sought the injunction said they were going to be irreparably harmed, but it turned out they wouldn't be because they lost. So the party that was actually harmed by the entry of the injunction was the party that was enjoined from selling the property. And so they're entitled to compensation for their damages, and that would be in the form of the bond. And it's not just automatic that you would turn over the value of the bond to the other side. There's a hearing on releasing the bond, et cetera, et cetera. But that is the purpose. Some injunctions you issue may have little to no economic effect on the other side in terms of losses. So it's purely situational. And sometimes bonds can be enormous. The entire worth of the case. And a bond, you can satisfy a bond by putting up your own assets. That's not a bond, actually. You're just putting up your own assets, and it's being held essentially as security. But many people, for large companies, for really large, bonding requirements, can't do that. So they have to go to a bonding company, and they charge a fee, 5%, 10% of the amount, and you don't get that back, even if you win the case and the bond never pays. So again, TROs and preliminary injunctions aren't free, right? Your clients have to pay the legal fees, and then pay for a bond or put up their own assets and risk that being at issue if you don't prevail at the end of the day.
Right. And for those of you who are new to this, some of the websites of some of the U.S. district courts, they will actually have a list of approved bonding companies that you can go to. So, to take the cautionary note that everybody has struck already, when you're getting ready to do this, make sure you know which bonding companies are acceptable in your district, because you don't want to win and then lose because you can't get a bond from an approved
I would
bonding.
take that one step further, Steve. If you're moving for a TRO, timing is everything, which means don't just know a list. Find one
Yep, have them
and
lined up.
have it ready.
Yep.
Overestimate the amount of the bond and make sure they're going to be willing to bond it. Because I can tell you, I've been involved in TROs where we have, run around the other side because they weren't prepared with the bonding companies. And if you're delayed 2-3 days, that's a big deal, because that TRO will not issue until the bond is in place. Now, it's pretty bad form, and you risk really angering your judge if you go ahead and do whatever they were trying to enjoin you from when the judge has already indicated he's inclined to enter the injunction as long as the bond is posted. But nonetheless, some litigants, think that's worth the risk, especially if you're in jurisdictions where you just get an emergency judge and the judge that you're at risk of angering isn't going to be your judge for the rest of the case. It's often the case if you go in on an emergency that you don't get assigned via the wheel, and different in the wheel is, basically the random assignment process. So, again, these are tactical considerations that are unique to jurisdiction. And even I'm in Illinois, even county by county, it differs significantly. And if you go in for a TRO, will you get an emergency judge? Will you get a cradle to grave, beginning of the end, to the end of the case type judge? And it actually depends within Cook County, what is the nature of your case?
Right.
Is happen. So this is a huge number of moving parts in the strategic calculus as to what you do. But the number one point I think you've heard from all of us is you have to have it all buttoned down before you go in. All these little details.
Right. And so let's talk about those strategic considerations from the other side now. So Tim, let's go back to you. You're now defending against a TRO. What are your strategic considerations? What are your best practices when you're on your back foot from the outset?
So there are different scenarios that can play out. It could be a circumstance where you've had a back and forth with your adversary over a period of days, weeks, or months, and you're fully expecting them at some point to take action, and you're prepared to take action. Now, it would be unusual for it to be days, weeks, and months if it's an emergency, but perhaps the dynamic changed. Perhaps there was a dispute of some kind, and then something occurred that made the dispute irretrievable and led them to seek this interim restraint from the court, but perhaps you have some background on the matter. Other times you're contacted without any meaningful notice, maybe the 24-hour notice or maybe even less, and you don't know the facts and circumstances of the case. So let's assume that's your scenario. In that instance, you've got to connect with those who have personal knowledge of the dispute as quickly as you can. Typically, it would be your client. Could be multiple people within your client's organization if it's an entity or a corporate entity, and you want to gather facts from them as quickly as you can and memorialize those facts in affidavits that may help oppose the motion. You also may gather documents from them, documents that perhaps indicate that there's no basis for the relief sought, perhaps documents that support the contention there's no likelihood of success in the merits, or perhaps documents which reflect that this is a money damage case, if anything, meaning there's no irreparable harm that will result, or something that can assist you in attacking each of the elements that the other side needs to prove to demonstrate their entitlement to the relief. So if you can demonstrate that at a minimum, there's money damages could be sufficient. Now, no one wants to pay the money damages, right? I've had plenty of people say, money damages are sufficient. And then if they succeed on that argument, they will later argue, there's no money damages, right? It is this two-step process from a defense perspective and really from a plaintiff perspective as well. So you want to be prepared to know the case as well as you can know it under the circumstances, bearing in mind that you're likely to learn more about the case as you go forward beyond this stage if the case continues. But you want to jump into it as much as you can and command the facts, memorialize the facts, and present those to the court. You also want to be in a position to argue there's no need to rush. This is not an emergency. This is not the type of application that warrants interim restraint. If they think they're entitled to an injunction, you can just put it on for an injunction hearing weeks or months from now, and we can attend to it. So you want to communicate to the court that the emergency that has been presented by your adversary is misleading, and there's indeed no need for the court to take such a drastic remedy at this stage, that we can have a more full and complete hearing, perhaps with additional exhibits and evidence and even perhaps testimony from witnesses. So that's kicking the can down the road, but you'll do what you can do to defend your client from getting that TRO issued against them. Another point of attack, to Jeff's points earlier about the bond, is you can argue that indeed they do need to post a bond with the hope that they cannot post a bond, or you can argue that the bond that has been proposed by the applying party is insufficient in some way, and argue that there needs to be a greater and more substantial bond posted. And sometimes, as I noted earlier, plaintiffs don't have the wherewithal to post a bond of significance. So there are a number of points of attack, some merits-based, some standard-based, and some logistical-based points of attack. But ultimately, first step, get to know the case as quickly as you can and be prepared to go in as quickly as you can to defend your client.
So Jonathan, let's say that Tim did all of those things and you still got a TRO against Tim's client. What should you do next on behalf of your prevailing client?
Sure. And there's a number of things that you want to be sure that you accomplish and accomplish quickly. The first is that you want to make sure that your order that you've submitted is clear and capable of being enforced. The federal and state rules all have specific requirements on what must be in these types of orders. Under Federal Rule 65, every TRO or preliminary injunction must state the reasons why it is issued, state its terms specifically, and describe in reasonable detail, and not by referring to the complaint or other document, the act or acts restrained or required. And you want to take great care with the proposed order, because just because a judge is willing to enter the form of order that you've submitted doesn't necessarily mean that it's the best or most effective order to accomplish what you're seeking to accomplish. I've seen many cases where counsel spends a lot of time on the motion and on the briefs and on the affidavits, and presents an impeccable motion for a TRO, and then slaps together a proposed order that has boilerplate language and more holes than a block of Swiss cheese. And lo and behold, later on, when they go to try to enforce the order, it's ambiguous, or it's not as clear, or it doesn't specifically enjoin the conduct that you were hoping to stop. Arguably, this is one of the situations where the order itself, the proposed order that you submit, is probably one of the most important pleadings that you're going to submit to the court. Second, once you get the order, make sure that you provide notice to all of the parties that you hope to restrain and that you hope to make subject to the order. Under the Federal Rule 65, a TRO has the potential to bind the parties' officers, agents, servants, employees, and attorneys, and any other persons who are in active concert or participation with those people, but only if they've received actual notice of the TRO. So again, you've done all the hard work. You've put together your motions and your affidavits, and you ran into court and you convinced the judge to enter the order. You've got a nice solid order that the court has entered. But you need to provide actual notice to the parties you hope to make subject to that order. So don't gloss over that last element. Make sure they get notice. Third, you have to promptly post the bond. I'm not going to belabor Jeff's point. He succinctly described the bonding requirement. It's a necessary element and for your order to be effective. So make sure you're prepared and ready to post the bond once you get the order, or I guess post the bond before you get the order. And then finally, be prepared to enforce your TRO if you have to. Just like any other order, courts really don't like when parties disobey the court order, but they're not going to know what the other parties are doing unless you bring it to their attention. And so if you have an opposing party who's just violating a TRO that you've obtained, you may need to move quickly to hold them in contempt. You can seek civil contempt, potentially sanctions, or even in egregious situations, criminal contempt. But you know, an order is only as good as the enforcement behind it. So be prepared to monitor the conduct of the other side, and if you need to enforce order, be prepared to move quickly to do so.
So, Jeff, you were co-counsel with Tim against Jonathan. Jonathan got his TRO. What are you telling your client based on what you just heard and your experience? You know, hey, this TRO has been entered against us. What are you telling your client to do and not do?
I'm telling them to comply with it, because it's a court order. But there's a series of tactical considerations that, and I want to back up a step, because Tim talked about defending the TRO as in you always want to go in and oppose it. That is not always the case. Okay. Sometimes you get the TRO papers, you look at it, and you're like, I can't get together a sufficiently good response in time where I'm likely to persuade the judge. And maybe what you do is you instead try to negotiate a short-term agreement with the other side where you won't do it. And that gives you some time. Or if you see the judge is going against you, you ask the judge if you can talk to opposing counsel, and you go outside and you try to negotiate something. Sometimes you realize that based on the TRO, they're painting you as a big bad bully. And if you actually went ahead and did what they're accusing you of, you may actually look like the big bad bully that your defense strategy is going to claim you are not. Right? So for example, you know, I had a case where certain services were being provided to competitors by my client, and my client wanted to get out of that business completely. And so they were going to shut those services off. And these smaller competitors who were reliant on these services said, you're going to put us out of business, you know, and filed an antitrust case. Well, if you have market power, if the allegation is you have market power and you actually turn around and put these companies out of business, even if that's not your intention, you could look bad, right? So we actually conceded to the TRO. Sometimes you think you're just better off getting quickly to a preliminary injunction hearing. And you're much more likely to get a quick preliminary injunction if there's a TRO in place, right? To get it scheduled. Because the judge knows that's temporary, it's got a very short shelf life, and it's got to get done. So there's a whole bunch of circumstances, and you're talking about that with your clients before you go into court, and you're talking about it after, when you get out. You know, if you get the TRO entered, you have to sit down and have a serious conversation with your client on making sure they don't violate the law, and what their options are. Do you want to appeal it? Do you want to just let it stay in place? Do you want to redouble the effort when it comes up for renewal and, you know, put in a bunch of new evidence that you hadn't put together? You know, you have a panoply of options that are available. Appeals can be very difficult because they're on extremely short timeframes. like in Illinois State Court, it's 72 hours, right? You have to file, it's like 72, 24, and then the appellate court has 24 hours to rule. Right, they're gonna put a lot of trust in a trial court who, you know, as long as they follow the procedures, right? The put in the things that Jonathan noted are required. They're that's going to be a very difficult task in most instances to get a TRO reversed. So, you know, it leads to hard conversations. You know, with a client who likely doesn't want to abide by the TRO.
All right, let's talk about hard conversations. So Tim, you went to court to get a TRO for your client and you lost. That's a hard conversation. What do you do next?
Well, it can be, but there are circumstances where when you filed the TRO, you knew there were vulnerabilities. You knew that there was a chance, for example, that the court would find you were not irreparably harmed and that money damages may suffice. So it may be that your conversation with the client, while yes, you of course wanted to enjoin the conduct of your adversary, you wanted that restraining order, but maybe you've got a claim for $100 million that you can then advance. So I'm not suggesting it's a happy experience to lose after working so hard to seek the temporary restraining order. But in some cases, losing the restraining order motion does not mean the merits of the case are adverse to you, because the judge may have ruled on a different ground. If, on the other hand, the judge made a merits determination, essentially finding that you do not have a likelihood of success on the merits, well, that could ruin your whole case, because losing on that basis suggests that proceeding with your underlying complaint, which, remember, is representative of the balance of your lawsuit. If you want to pursue your underlying complaint, but you've gotten an early determination by a judge that you don't have a likelihood of success in the merits, it takes the wind out of your sails, it emboldens your adversary, and it spells trouble for the likelihood of success of proceeding forward on the merits. But again, judges make different determinations based on different standards. If it's a determination you are not irreparably harmed, you can continue to pursue your money damage case. If they made a determination that your papers were procedurally deficient in some respect, you might be able to refile. But because, as Jeff and Jonathan have alluded, that the time is so critical, refiling a temporary restraining order motion is not an ideal circumstance. But if there's a procedural defect and you can rapidly cure it, maybe in your client's best interest to do that. You also may be in a position to negotiate with your adversary. Now, you're not in as good position for sure, but if they are facing the prospect of money damages going forward, then they may be willing to negotiate some resolution with you. Yes, you have lost some leverage by not getting the TRO, but depending upon the facts of the case, you may have some leverage. We had a case recently where we pursued a restraining order for someone that had effectively already violated a non-compete and was continuing to violate it. And the court essentially said, you know, I'll grant you partial relief so that to the extent they have any of your confidential information, they are restrained from using it. So that was good for us, but I'm not going to restrain them from doing business with this competitor. You can seek money damages for that. So sure, that was a partial loss, but we have a substantial money damage claim against them, and we intend to pursue it. And finally, the point I'll make is that you may have some appellate rights. I think Jeff alluded to this a moment ago, but getting an appellate court to reverse a trial court on a temporary restraining order would be very challenging, and getting them to do it quickly and sufficiently fast for you to get the relief that you need when you need it, that's a challenge. That's not a position that anyone would want to be in, but in many jurisdictions, it is available to you. It's just not an advantageous position to be in.
Yeah, hence my example earlier in Texas. Jonathan, let's go back to you. We're about 10 or so minutes left in the conversation. So Tim touched on this. Let's just dig a little bit deeper before we move on to preliminary injunctions. So, win or lose, there's often settlement discussions between the parties following a TRO hearing. How do you best position your client to have that conversation?
Yeah. And when we're talking about settlement negotiations, I think there's really, I view it as kind of two types. One is kind of a settlement of the entire litigation. And, sometimes that can't happen at the outset, especially if the judge has made some, preliminary rulings on a TRO or a preliminary injunction that are favorable to one side or the other. It may set the stage for, for a resolution of the entire litigation. But probably more often, there's a chance for settlement discussions, at least over the entry of if you're at the TRO stage, maybe a TRO was entered, and now you're scheduled for a preliminary injunction hearing over the terms of a preliminary injunction order that both sides can live with during the the pendency of the litigation. And if you're the plaintiff, I mean, I think to position yourself in the strongest possible spot, you want to try to get as favorable of an order as you can at the TRO stage. You want to hopefully kind of color the judge's view of the case early on. Convince the judge that you have a strong case. Convince the other side that you're going to be showing up with receipts and with witnesses at that preliminary injunction hearing, and you're going to get a favorable order at that hearing. And so you want to put yourself in the strongest position possible. If you're the defendant, and maybe you lost at the TRO stage, you need to work very closely, as Tim said, with your client to gather evidence, as quickly as you can. Presumably in most cases, if you're the defendant, as Tim mentioned, you're called in once the client learns of the litigation, which is generally after it's already been filed. So as defense counsel, you're probably the least informed person in the proceeding, at least in the early stages. So you need to quickly gather evidence. And if you can get together witnesses and favorable documentary evidence, and show the other side that there's a strong likelihood that they may not be successful at the preliminary injunction hearing, that certainly strengthens your hand in any settlement discussion over the litigation writ large, or on the entry of at least an agreed order during the case. And then for both sides, really, you've got to work closely with your client. You got to understand your client's business objectives. You got to understand, what can they and can they not live with, during the pendency of litigation. So, oftentimes the parties can find common ground on an agreed order, at least during discovery and during litigation, even if they can't resolve the entire conflict.
Right. So we spent a lot of time talking about TROs and what happens after TROs. Let's assume, Jeff, that the conversations Jonathan just described did not lead to a consent order for injunctive relief. And it's now time for the PI hearing. You're representing the plaintiff. How best should a plaintiff prepare for a PI hearing?
First of all, have a lot of coffee available, because you're not going to sleep a lot. You're probably going to have discovery. You're going to have depositions. You're going to have to produce documents, all on a very expedited basis. It's a bench trial, right? It's just that the judge isn't going to make an up or down decision. You win the case or you lose the case. They will make a decision, maybe, on likelihood of success on the merits after hearing all the evidence, or they may just make a decision and say, you know what, I don't think you need the protections of a preliminary injunction, because I don't think your damages can't be adequately compensated, with money. You take some risks in moving for a preliminary injunction, right? If the judge rules you don't have a likelihood of success on the merits, that's often the death knell. Cases often don't proceed past that. On the other hand, if you get a preliminary injunction, that really turbocharges settlement discussions, and usually, things end there. it can be tactically a good thing if you want to put people under oath and not give them as much time to develop their defense, and kind of lock them in testimonially. Um, to push for a preliminary injunction, even at the risk of getting an adverse determination from the court. Again, it's a lot less harmful to get an injunction denied because your damages aren't truly irreparable, as opposed to the judge saying you don't have a likelihood of succeeding on the merits. But it's a trial, it's very condensed. The period in between the TRO and the preliminary injunction. And, if you're working for your client on an hourly basis, you need to, have realistic conversations with your client about, they're going to have to pay you, quite a bit of money in a shorter period of time, but on the other hand, a lot of that work that you're doing is work you would have had to have done later on, but instead you're going to have to do it a great deal of it in a shorter time period.
Right. And so let's now go to the other side of the aisle. Tim, you're defending against a preliminary injunction. We have a few minutes left, so let's talk about what it is you would do to defend against a PI.
Well, first of all, you have to determine whether the hearing will be an evidentiary hearing or whether it will be argument. We've been talking about this in the context of evidentiary hearings where witnesses are presented like a mini trial, and that will often be the case for a preliminary injunction. But I have a case in Chancery Court in Delaware right now where we were scheduled for a preliminary injunction hearing this month, and we've since gotten the injunction, thankfully, and without the need for hearing because it was a stipulated injunction ultimately. But the hearing was going to be arguments from counsel. It was not intended by our judge in that case to take live witnesses. So judges will deal with this differently, and that is a threshold issue for you as counsel defending against the preliminary injunction to understand. Are we arguing on the briefs and arguing points of fact and law that are derivative of exhibits? And likely there's a chance that you will have taken depositions by the time you get to a preliminary injunction. There's also a chance that you would not get depositions. So for example, if you get a TRO, or pardon me, if your adversary gets a TRO and the court schedules an injunction hearing in a matter of days or weeks, you may not get an opportunity to take depositions before that preliminary injunction hearing. You may go in without the benefit of testimony of your adversary. So you'll have to be prepared for that in any direction it may go. I was a prosecutor, so this is analogous to being a prosecutor where you cannot compel the defendant to give a statement because that would violate their constitutional rights. However, they may step up and testify at trial, waive their right to remain silent, and you've got to adjust on the fly as you question them. So you have to ultimately be prepared to question witnesses, whether you've already taken their depositions or not. You've got to be prepared to argue that there's no irreparable harm. You've got to be prepared to argue that there's no likelihood of success on the merits. And depending upon the case, you may focus one direction or another. By the time of the injunction hearing, you may know enough to argue the merits and hope that you can knock the whole case out, essentially, because you would undermine the case if you get a finding that there's no likelihood of success on the merits. Or it may be that you're not as comfortable there, or maybe they do have some merit to what they're saying, but they really are only entitled to money damages at best. So you have to determine which angle to attack. And that will depend upon your consultations with your client, your study of relevant points of law, and the underlying exhibits and evidence that have been developed to that point in the case.
So we are almost at the hour, so I'm going to jump ahead to our sort of catch-all and give each of you a chance to tell our audience, any final thoughts, best practices, traps for the unwary. Jonathan, let's start with you. What would be the takeaways you would like our audience to have?
I would say that, one of the most important aspects is that you need to be in very close contact with your client. This is a process that moves very quickly. You may have a matter of hours, a matter of days to respond, to present evidence, etc. And unless you have a good line of communication with the folks at your client that have the knowledge, it's going to be very difficult either to prosecute or to defend a TRO or preliminary injunction. So you need to be in close communication with your client all along the way.
Excellent point. Jeff, what's the takeaway you'd like our audience to have?
TROs should not come as a surprise to the litigant in most circumstances. So you have to be prepared accordingly. And to loop in what Jonathan said about talking to your client, make sure you're talking to your client when they're locked in a conflict, not to take any inflammatory or peremptory actions without running it by you, right? So that you can assess whether it's likely to trigger a lawsuit in an immediate TRO and advise your client accordingly. You don't want your client doing something that catches you flat-footed.
Absolutely. Tim, last word. What is your best takeaway for our audience members?
Best takeaway is to be realistic, which means if you're the plaintiffs considering this type of restraint, you have to be realistic of your opportunities for success and what impact it could have on your broader case. Similarly, if you're defending, you have to be realistic. Where can you defend? On the merits? Or can you defend on irreparable harm? You can defend on the amount of the bond. Be realistic where your best points of claim or defense reside and advise your client, manage their expectations, and then pursue your strategy.
Excellent points, all. So we are just past the top of the hour. So this will conclude our webinar. On behalf of the panel and myself, thank you for joining another entertaining and educational production of Financial Poise. Thank you all.